event. I think everybody knows Justice Edwin Cameron. You could say, people often say, Edwin needs no introduction, but I'll give him a little bit of an introduction, not too much. I just want to say, I first met Edwin 20 years ago here, and I think it's good that we're standing here because 20 years ago, Edwin worked from the law faculty here, operated out of that funny building over there, and 22 years ago, Edwin founded the AIDS Consortium, and 21 years ago, founded the AIDS Law Project. Both organizations that belonged to the Center for Applied Legal Studies, that grew out of the Center for Applied Legal Studies, and organizations that, together with Edwin himself, most powerfully, have helped shape the response to the HIV epidemic in South Africa. And so, before Edwin speaks, I just want to say that Edwin is an inspiration to all of us. I think many of us in this room feel that we are Edwin's children and have grown in his feeding off his inspiration and his ideals and the organizations that he decided to bring into being. So it's really very apt that as we celebrate three great organizations, LHR, CALS and the Legal Resources Center, that we do so with one of the heroes of constitutionalism and human rights, Justice Edwin Cameron. So over to you.
Good evening, ladies and gentlemen. How are you? I might say that Mark is absolutely right to say that I feel very fatherly because you all look so young. Can I just do a quick census? How many of you were not yet born when CALS was born in 1978? Please put up your hands. Alice. And having received Mark's very generous tribute, for which I thank you very much indeed, Mark, I do want to recognize one of the lions of the struggles of that time, and he's standing right there, Dennis Kuniesi. Dennis, thank you. Ladies and gentlemen, I have to make a confession to you. I totally misjudged this occasion. Alice wrote to me and she said, say a few words. Well, a few words would have been appropriate, but I prepared a speech. And I'm going to give a speech. Is that all right?
Yes.
Thank you very much. But before I give the speech, I want to say something about sibling rivalry that Jacob rightly raised. We were terribly jealous in those years, the late 1970s and the early mid-1980s, of the high salaries that the people at the LRC got. We were getting academic salaries, and the people at the LRC were getting practitioner salaries. So now we know why you do all this public interest work. And Jacob, we were terribly jealous of the media profile that Brian Curran used to get for Lawyers for Human Rights. Brian Curran was a very glamorous human rights lawyer in the 1980s. We were all very, very jealous of him. Do you agree that Jacob is much more glamorous than Brian? And we also had a lot of fun. I also want to recognize that Alice, who's organized this conference and asked me to come and speak here this evening, actually funded our work at CALS. Do you remember, Alice, that you used to be a Ford Foundation South Africa program?
I'm so old, I forgot.
And I really want to pay tribute to our supporters and funders and the people like Alice who had belief in what we were doing at a time when it didn't seem likely that what we were doing would lead to anything constructive. So I want to pay honor to Alice and to her colleagues as well. But we also had fun. And we were also terribly naughty. And the worst example of the naughtiness is something that I shouldn't tell you, because it concerned Raymond Suttner, who had been released from prison for the anti-apartheid struggle, and then came and was appointed as a lecturer at Wits. And the first emergency was declared very nearly 29 years ago, just more than 29 years ago, in June 1985. And the second emergency was declared 11 months later in June 1986. And Raymond was arrested under the second emergency and kept in solitary confinement at Deep Kloof Prison. And we brought an application to secure his release, and we thought we had strong grounds. And we were unfortunate enough to draw a judge called Judge Monas Fleming, who was not impressed with our arguments, not impressed with the application papers. He gave me a terribly hard time. I spent the whole day arguing before him, and at the end of a terribly calamitous and disappointing day, when you think, what is the law about? We got back to CALS, and Helton was my instructing attorney, Helton Cheadle. The LRC had Jeff Buttender, but we had Helton Cheadle. And Helton Cheadle walked into the CALS library, where Ferial Haffergy, by the way, was a library assistant. Wonderful. She started as the most gorgeous, beautiful, lovely, and wonderful library assistant anywhere in the world. And everyone was waiting for us. And we walked in and we were haggard, and I was carrying my robes and my legal bag. And Helton said, guys, there's good news and there's bad news. And I said, Helton, stop. And he said, the bad news is that we lost the application. The good news is that Raymond remains in detention. So we were very naughty and very politically incorrect. Those were heady days, ladies and gentlemen. And we are here, and I'm very honored to share the platform with the three current representatives of the organization. We are here to commemorate important events in their past, but I want to talk about the future. And this is because of a special belief that we shared, and a special belief that I think all of us here share as well, which is that the law in our country is a uniquely valuable instrument of social change in order to secure social justice. That belief was forged under apartheid. Its roots lay in the Roman and Roman Dutch law that the Dutch settlers brought to South Africa in 1652, and which was overlain in the 19th century with the forms and the processes and the institutions of the English law. The result was a complex, sophisticated hybrid legal system, and the dramatic change in the fortunes of the law came in 1948, when it was employed to systematize a uniquely pernicious system of human degradation, subordination, dispossession and exclusion on racial grounds, which was apartheid. But early on in formal apartheid, lawyers and activists took hold of an acute insight. The insight that while the law was to be the chief instrument of enforcing apartheid, conceptualizing it, executing it, it could also be used to thwart its achievement. The Defiance campaign of the early 1950s, the massive treason trial that followed in 1956, the Rivonia trial in the 1960s, resulting in the imprisonment of almost the entire internal leadership of the ANC, all of these, which represented setbacks to the law, only served to underscore an intense underlying conviction of a small cadre of lawyers in South Africa, that enlisting the law in the service of apartheid was a perversion